right, there we are. Happy Thursday. Welcome to your contract to close, Purchase Ready Academy training, virtual lunch and learn. So listen, I want to let you guys know, virtual lunch and learn. I realize that this is at noon, and most times this is on your lunch break. And many of you are on camera, and I absolutely appreciate that because I want to see you, see me. But if you're like, Ray Cole, I need to eat, that's fine. My lunch is this green smoothie. um, just want to put that out there. Grab lunch if you got to go off camera for a second because you know, if lunch is really good, that's fine. But I definitely want to encourage you guys that when we come together on this Thursday, grab something to eat. Let this be your downtime, right? Before you go into, either your next appointment or your showing or whatever else is going on for the day, right? So feel free to grab lunch. Hey, Arturo. All right. So today's discussion is protect the escrow deposit. We know that the loss of an escrow deposit is the worst possible outcome for a buyer. It is the worst possible outcome for a buyer. And as much of a threat as it is in every transaction, it is absolutely avoidable, right? And so today's discussion, we're going to really quickly go over how do we protect the escrow deposit? What are some instances in which the escrow deposit is at risk, and how do we avoid that? For those who I have not had an opportunity to meet before, I see a lot of familiar faces. But for those who I've not met before, nice to virtually meet you. My name is Ray Cole Jackson. I'm a South Florida real estate attorney. Many of you may know me as the founder of Title Experts. Originally, I am from Miami, Florida. I attended the University of Florida, so go Gators. You know that I always say go Gators. Moved on to Santa Clara in California, where I got my LLM. I got my law degree from Santa Clara. I had my LLM in a real property development from the University of Miami, came back home. And I am also along with being a licensed sales professional, like many of you. Anne Marie, you see nothing and hear nothing. Can everyone else hear and see? Yeah, many chat with, okay, perfect. Chat with Anne Marie and make sure, Anne Marie, maybe you need to go out and come back in. Along with, like you guys being a licensed real estate sales professional, I'm also a licensed loan officer. So also do lending. With that being said, I enjoy real estate. I enjoy all things real estate. And so when we come together and have these discussions, it is my goal to make sure that as real estate professionals, you guys are able to see that transaction 360 degrees, see all parts of that transaction. Even if you have not yet been exposed to all parts of it, I'll help you. I'll show you what's going on in those different, on the other sides of the transaction. With that being said, because of my licensure and experience in all facets of the real estate transaction, we have developed a full service ecosystem, a full service offering for buyers and sellers as it relates to their real estate processes. It is to streamline every step of home ownership. You guys hear me mention this on prior trainings, how we're going to get into this more. I want to make sure that as real estate professionals, you guys know where this industry is going. Your buyers, your sellers, they rely on you very heavily to be their point person in their transaction. And so with that being said, it is important that you too have a 360-degree understanding to the extent possible, working knowledge, as I say. But I also want you guys to make sure that you structure your businesses as a full service ecosystem, even if you're not licensed as a loan officer yet, right? But you have a lending team that you work with so closely, and your customer journey is so in sync that it's seamless, right? You're as the title agent, the closing team that you work with, you guys are so in sync that it's seamless, right? And then of course the real estate service that you provide, it is so in sync that it is seamless. And so I want you guys, as you continue to work on your offering, make sure, to the extent that you, number one, get yourself comfortable with the different spaces, become comfortable with lending. If you show up here every Thursday, you will. As a matter of fact, next week we're talking about clear to close, right? So we're going to go over the lending process. So if you've not ever really walked through the lending process before from a 30,000 foot level, you'll do that next week. And so you'll hear that messaging, and then we'll talk more about it to the point where, no, I'm not the loan officer, but I understand it enough right? To be able to hold myself out to my buyers, my sellers, as a real estate consultant, a real estate professional, not just as it relates to the property, but as it relates to the transaction as a whole. All right. And then, of course, we always talk about your duty as a real estate agent, you know, contracts, showings, all the listing agreements, of course, the escrow deposit today. And then with title, the last week in this month, we're going to talk about the closing process. I'm going to bring you behind the desk of a closing agent so that you can see the contract to close process from the title agent's perspective. Again, giving you working knowledge. So this won't be something that you've like not heard before. Okay. And so all of that 360-degree information is housed under Purchase Ready Academy, right? Under Purchase Ready Academy. Purchase Ready as an entity provides those services, lending, real estate, and title. Purchase Ready Academy provides the realtors that we work with the knowledge, experience, and exposure that they need to duplicate, right? You become your own one-stop shop in real estate. Now, let's get into today's discussion. What is an escrow deposit? What is an escrow deposit? An escrow deposit, as we know, is a buyer's good faith gesture to the seller. It is indicating how serious the buyer is about purchasing the property. So the reason why I say how serious they are is because a seller understands that, I'm sorry, handout is in the chat. Link to the handout is in the chat. I always zoom right past that. The link to the handout is in the chat. Guys, grab that so that you'll have some quick notes of today's discussion, right? We know that the escrow deposit is the buyer's representation to the seller. This is how serious I am, right? Here's my $20,000. If I default, if I don't close on this property, I understand that this $20,000 is at risk, right? This is not the same as their down payment. I want to make that point because that question was brought up a couple of weeks ago. It's a very good distinction. This is different from your down payment. Down payment on a loan is it's going to be a part of the buyer's cash to close. Their escrow deposit comes up front when they go under contract. All right. So good terminology distinction to make sure that you're aware of. As I mentioned before, the escrow deposit is also generally what we call the seller's liquidated damages. Now, liquidated damages is a legal term. Liquidated damages means this may not be in fact what I lost, but this is what I will accept in exchange for my loss. It could be. Now, a seller could go forward and ask for more. However, this is generally what they're going to accept as their compensation for loss under this contract or this transaction. All right. So today we want to point out what are the junctures in the transaction that are most prevalent for default that would place the buyer's escrow deposit at risk. For that, you have to know the contract. And we've been going over this contract ad nauseum, right, over the past few weeks. And so you're going to see, and I'm glad that we did it this way, because those of you who have been here, you're going to see how these concepts just repeat themselves. These concepts just repeat themselves. And so once you get so comfortable with this contract and the most critical concepts, then you're like, you know what? Got that in the bag. We're good there. Let me focus on the other parts of my business, right? I know that many realtors, especially in the beginning, you're so consumed with the contract and making sure you don't mess up, which you should be. You absolutely should be. But I want to tell you that those 12 pages don't change. Those 12 or so pages, depending upon how many addendums you may add to it, they don't change. And so once you get those 12 pages and a couple of writers that you commonly use, once you get working knowledge of those, once you printed them out, you marked them up, you've identified where your landmines are, then you're like, these are the hot points. As long as I have these buttoned down, then I'm good, right? So know your contract. So last week we talked about knowing how to determine the effective date of the contract. I told you guys last week, if you get the effective date wrong, then 9.9 times out of 10, you're going to get your deadlines wrong, right? And so we talked about how to determine the effective date of the contract. A brief recap: the effective date of the contract is the date when the contract is fully executed and delivered to the other party. Executed and delivered. Today is May 15th. Contract was executed yesterday, 14th, immediately. Buyer made the offer on the 14th at 12 o'clock. By 12:05, the seller had fully executed the contract, accepted it. However, they got busy. They were getting ready to watch the Warriors. And they started getting their food together, right? We know what happened. If you're a basketball watcher, you know Warriors lost. They were devastated. Just went to bed. Couldn't be bothered with it. Woke up this morning, kind of feeling okay about the fact that the Warriors have been knocked out of the playoffs. Oh, I need to send over that contract, that $50 million contract. I guess I'm still excited. Well, our effective date, although they signed within 5 minutes on yesterday, the 14th, our effective date is today, the 15th, because it was delivered today. It is execution and delivery. So for that reason, I want you to remember that the full definition is executed and delivered, right? But if you can only remember one, remember delivered. When was it delivered? When did I get it? When did I get it? The date that I received it, that the final party received the fully executed contract, that is your effective date. Or when did the other party receive it? If I represent the seller and I know I couldn't even get him on the phone after he got that $50 million offer, right? He was so excited. He's like, well, my work here is done. I'm going to go prepare for the watch party. Couldn't even hear from him, right? But I know that I didn't get it over back to our tutor until today. Today is the effective date, right? Got to drill that point in because I get that question from realtors with 1 day of experience and 100 years of experience. It just happens. But again, you guys don't have that issue, right? So you're clear on the effective date. So you know now that you're counting from your effective date for your deadlines. One last point I want to make a reminder of: the effective date is day 0. If you missed last week, make sure we're going to have the QR code and the access link. And Minnie may drop it in the chat at the end because I don't want you to get distracted, so that you can access School. School is our online community where we are uploading and housing these recordings as well as the handouts. All right. So the first possible point of default is the buyer's failure to make an escrow deposit. Now we know that generally the buyer's going to make one escrow deposit. If they don't make the first escrow deposit, then what's at risk, right? Technically, they don't have anything that is in an escrow account to be withheld, right? So technically, they are in default. Technically, the escrow deposit they should have made should be the seller's remedy. But I mean, the money's not there. What are we talking about, right? I've literally had conversations with people where they're like, "Can we force them to send them?" And like, seriously, no. Just cut your losses, place the property back on the market, go get another buyer. Now, if that contract called for a second escrow deposit, they made the first, defaulted on the second, now we're having a different conversation. That first escrow deposit is at risk, period, right? So if you have a situation where your buyer has made an offer, executed contract calls for them to make multiple escrow deposits, failure to make any of those escrow deposits is a default. We know that the remedy for default most often is to retain the escrow deposit. So what are we going to do? Make sure that the escrow deposit is made, right? First escrow deposit, purchase price, first escrow deposit, additional deposit, right? And make sure that you count the date that is due properly. I had this question before, so let's go ahead and hit it. Let's say we put in here 3. No, let's say 10. 10. Let's have 10 in there. This is going to be within 10 days after the effective date, not 10 days after the first deposit was made. Just want to make sure that we're clear on that. This is 10 days after the contract effective date, not 10 days after the first escrow deposit was made. So for example, first escrow deposit was made on the 3rd. The next escrow deposit is going to be, let's say our effective date is the 31st. We're under a contract. The effective date is the 31st. 3 days, within 3 days of the effective date, that means that escrow deposit would have been due by the 3rd. Let's say April 3rd, May, June 3rd, whatever, June 3rd. If the second escrow deposit was due within 10 days of the effective date, this escrow deposit is going to be due June 10th, not June 13th. Are we clear? Not 10 days from when the other escrow deposit was due, but 10 days from the effective date of the contract. All right? All right. The next major point of default is failure to comply with the terms of the financing clause. This is where all the action happens, right? This is where all the action happens. Focus in right here. Paragraph 8, 8B, if it's finance, right? We know that the buyer needs to make an application for purchase of, if they're financing, then they need to make a loan application. Now, I've said this before, I'm going to say it again. If you're representing a buyer, if you've accepted an offer from a buyer, you're not under contract with the buyer who has not already been pre-qualified, right? Right. Pre-qualification / pre-approval requires that they have already made an application. So there's no reason that any buyer should default on this particular term of the contract regarding making a loan application. They've already made their loan application, right? All right. Loan application, line 97. They've already done that, right? Yes. Now, this is where the next deadline within the financing paragraph is where, think of it as like escalating issues, right? Loan application, not so much. They've already done that. I mean, you're not working with a buyer who hasn't been pre-qualified. You're not accepting an offer from a buyer who has not been pre-qualified or pre-approved, right? Next week, we'll talk about the difference between the two. At this point, now we have a loan approval deadline. This is important, guys. This is important for a number of reasons. At this point, we talked about knowing your deadlines. You need to confirm the loan approval deadline. Line 89, first blank. This contract is contingent upon within how many days after the effective date must you receive a loan approval or an outcome? Provide notice to the seller regarding the loan approval status. Focus in here. I'm going to give you a couple key concepts. Number one, make sure you calculate this date properly. Under most transactions, finance transactions, particularly, what I call this is the point of no return. Because this is generally your last contingency. What does contingency mean? Contingency means a basis for some action to take place. If then, right? Contingency is if then. If I don't get my loan approval, then I don't have to proceed. I can cancel. If you don't notify the seller by this date, then you may cancel potentially, but your escrow deposit is at risk. So think of contingency as if then. Something is relying on this particular matter, right? So we call paragraph 8 our financing contingency. If then, something needs to happen with regards to financing for something else to happen, right? Financing contingency in general is saying, I need to get financing for me to have to proceed with the transaction. And so this is your deadline. This is your buyer's deadline to notify the seller of their financing review. They're going to provide notice of 3 outcomes. And we're going to see this on the next slide. Either 1, yay, I've been approved. See you at the closing table. Two, haven't really been approved, but my lender is Superman, so I'm gonna roll with it. He said he can get it done. Or thirdly, and I see you guys question in the chat. That's good. Keep them in the chat. Keep dropping your question in the chat. I'm gonna answer them at the end. Or thirdly, oh no, Vicious, this is not gonna work. They're asking for tax returns. That's gonna take forever. Doge is cutting. I shouldn't say that's political, right? What's going on with the IRS? Nobody's in the office. I don't think I'm going to get my tax returns. I got to bail out of this deal, right? So those are the three notices that you must provide to the seller by this deadline. Okay? And failure to provide that notice has different consequences. First of all, if you don't cancel, we already know what that is. If you don't cancel because you're not approved, unless the seller is nice, that escrow deposit is likely going to be withheld, right? Option two, I didn't get an approval. Can I extend this deadline, please, Mr. Seller? If you don't have an approval by this deadline, that's what you want to do. You want to extend this deadline. You want to negotiate to extend this deadline so that that escrow deposit is not at risk. All right. And lastly, this doesn't happen often at all. It has happened before, but it was because of the buyer did something they shouldn't have done. You very rarely get an approval and then past this deadline are not approved, unless the buyer literally goes out and purchases a BMW, right, while they're still being approved. Which brings me to my next point. Guys, understand that at this deadline, this is not a full approval. This is when your buyer is going to get what they call a conditional approval, meaning there's some other conditions. And the conditions could be something as simple as right before closing, we need to make sure that your credit score hasn't dropped. We want to make sure that you still have a job and make sure that we still see those funds in your account. But those are still conditional. Those are still conditions. So this buyer does not have a full approval at this point. Now, with that being said, you want to make sure that you're in communication with your lender, with the loan officer. You don't want a conditional approval that looks like they just started this application. They're still asking for bank statements. Excuse me? Bank statements should have been with the application, right? They're still trying to get verification of employment. Excuse me? That should have been with the application. They're asking for tax transcripts from 10 years ago. Excuse me? Are we going to get this done? Because if not, I either need to extend the loan approval deadline or I need to cancel. Again, this is the landmine right here. If we don't have a clear conversation with the lender about whether or not this file is going to get approved, this is where you get into trouble. Okay? All right. So, written notice the contract calls for of the loan approval status delivered to the seller by that deadline. It is in the contract. It says written notice right here. Line 120, if buyer fails to timely deliver any written notice provided for in 8B3, this is where, right here, 8B3, let's go ahead and read it. We read a lot. If within a loan approval period, buyer obtains loan approval, buyer shall notify seller of same in writing prior to expiration of loan approval period. Or if buyer is unable to obtain loan approval within loan approval period, but buyer is satisfied with the buyer's ability to obtain loan approval and proceed to closing, buyer should deliver written notice to the seller confirming the same prior to expiration of the loan approval period. That was option 1 and 2. Option 3, if buyer is unable to obtain loan approval within loan approval period or cannot timely meet the terms of loan approval, all after exercise of good faith and diligent effort, buyer may terminate this contract by delivering written notice, there's a writing again, of termination to seller prior to expiration of the loan approval period. All of this must happen prior to the loan approval period. If you're still concerned about not knowing how to calculate your time periods, remember, go into the community, grab last week's recording, watch it, post questions in there, but you can't get this wrong. Can't get these dates wrong, okay? So whereupon the buyer provides notice, buyer is not in default under the terms of the contract, buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. If buyer fails to timely deliver any written notice provided for in paragraph 8B3 or 4 above, which is these two paragraphs, fail to provide that notice to seller prior to expiration loan approval period, then buyer shall proceed forward with this contract as though 8A above had been checked as of the effective date. What does that mean, Ray Cole? That means that financing contingency goes away. That's what all that language says. Remember 5 minutes ago, we talked about contingency, financing contingency. I must get financing. I must get loan approval in order to proceed. This paragraph said, well, if you don't provide notice to the seller by your loan approval deadline, that contingency goes away. Now you're operating like a cash transaction. You cannot cancel because you didn't get financing, because that's what 8A calls for. Right? Provided, however, seller may elect to terminate this contract by delivering written notice of termination to the buyer within 3 days after expiration of the loan approval period, and provided buyer is not in default under the terms of the contract, buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. That's a quick aside. We're not going to delve too much into that at all today, but I want to make sure that you understand what that line is stating. I talked about this before in prior training. What that last line is stating, let's say the buyer is option 1. They're solid, golden, no conditions to their approval. They're under contract for 10 million, property's worth 20 million. Somehow, some way, this got away from the seller. And the seller is like, what? I'm selling a $20 million property for 10 million? Get me out of this, Cassandra. Cassandra, get me out of this contract. Cassandra's like, there's not many reasons for a seller to be able to terminate a contract, but in her mind, she's like, I have one possibility. She knows that it's a finance transaction. She knows that in 8B5, if the buyer does not provide written notice of their loan approval status, the seller can jump in that and can take the wheel and cancel. Again, don't want you guys to go too far into that, but know your contract. Know that is in your contract, right? So maybe the buyer's escrow deposit is not at risk, but guess what is at risk for failure to provide written notice to the seller? The whole transaction itself. Seller can deliver notice of cancellation, put it back on the market, and go and get that we have somebody in the waiting room, and go and get that $20 million, right, that they aspire to. All right. So recap. Once you get to the loan approval juncture on a finance transaction, 3 types of notice to the seller. One of these 3 is required. 1, loan approval, and it's conditional loan approval. We know that conditional loan approval is received. Yes, see you at the closing table. Option 2, loan approval not received, but I'm going to roll the dice. My loan officer said they could get it done, so we're going to proceed. Or option 3, it's just not going to happen. I can't get tax returns from 5 years ago in the next 3 days. It's just not going to happen, right? One of those forms of notice needs to be provided to the seller by the loan approval deadline. Okay? All right. Inspection period. Let's say, for example, this is a cash transaction. If it's a cash transaction, unless there's some other built-in contingency, this is the cash buyer's point of no return, right? With a finance transaction, inspection period deadline generally comes first. You won't be able to cancel for any reasons related to inspection. If there's a reason to cancel with regards to financing, then there's that cancellation provision. However, let's talk about a cash transaction. There is no financing contingency that's coming after the inspection period. There's nothing else, generally. So this is their deadline, right? To cancel without their escrow deposit being at risk. Keep that in mind. We know our inspection period provision in the contract, paragraph 12. Failure to close on time, of course. I mean, that's expected, right? Look at it this way. They're past their contingency. Most times they're not closing on time if it's a finance transaction because they couldn't get their loan approval, right? Their final loan approval in time. So that is a reason for your escrow deposit, your buyer's escrow deposit to be at risk. All right. Now, understanding that, here's what I want to make sure that everyone understands. We know that the escrow deposit is the opportunity, the vehicle to make the seller whole. But I want you guys to know that there is a process, right? It's not just call the title company and say, oh, they're not ready to close, break hole, send us their escrow deposit. Doesn't work that way. Doesn't work that way. Arturo, I see your question. Go ahead and ask your question, just in case.
Yeah, you are going to go into the scenario when the condo or association still is to approve the buyer, assuming he did all the diligence on times and everything, but still we are waiting for the association to approve or deny. And I'm very, 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 very close to the closing date. So I'm here, I hear that the buyer is going to lose the escrow. It's happened to one of my peers, but I'm not sure.
So that's a very good question. That's a very good question. So I want to clarify. So Arturo's question is similar to we talked about last week. We talked about the HOA approval. The approval requirement is a burden generally of the seller, right? And so we're looking at defaults that are by virtue of the buyer's action or inaction, right? So if the buyer, for example, in that example, if the buyer had not made their application, then we're having a different conversation. But if they made their application and they've done everything that they need to do, there's a deadline that the condo rider itself is a condition. It says there in the top paragraph, I don't know, where's mine? Yeah. 1 second. I have my riders here. Because I'm not going to tell you guys to do something that I don't do. Condo rider. Really quickly. Let's see if I can get to this really quickly for you. It has
assuming that you are closing after the period to be approved, because
well, you wouldn't get there because right at the very beginning of the contract, of the rider, paragraph 2, association approval. If the condominium declaration of bylaws give the right to a buyer to approve, it says this contract is contingent upon approval. So they have to be approved. You're not going to close without the approval. And if the failure to close because you don't get the approval, then the buyer's escrow deposit is going to be returned. Again, assuming they've done what they needed to do. They can't not get documentation in, not make the application, all those things. If you can clearly identify that the buyer has made their application, submitted all the documentation, and they can't be approved, then we need to, and they timely notified, then they would get their escrow deposit back. I'm glad you mentioned it, and I have a slide about that at the end too. How are escrow disputes resolved? Number one, we know that paragraph 15 describes what a default is, right? And there are various remedies in the contract. Today, we're talking about retaining the escrow deposit, but we know that there's also litigation. You can sue for damages, right? You can sue for damages against a buyer and seller. Generally, we use the term specific performance against the seller, meaning specific performance means I am suing you to do what you specifically agreed to do. And in that case, it's usually to sell the property. You agreed to sell the property. This is a case for you to specifically perform, do what you said you were going to do. Now, with regards to a buyer, even though, guys, we're talking about retaining just the escrow deposit, I want you guys to know that that is not the extent of their exposure. They can be sued for damages, meaning this $20,000 that I'm holding, that I'm able to collect from you, does not make me whole, because I kept my property off the market for 120 days, and it could have sold for 50 million. It's using a very extreme example, right? So they can sue for an amount above the escrow deposit, right? The language says it here. If buyer fails, neglect, or refuses to perform their obligation under this contract, including payment of deposit within the time specified, seller may elect, means they have the option to recover and retain the deposit for the account of the seller as agreed upon liquidated damages, consideration for execution of the contract, and in full settlement of any claims, whereupon buyer and seller shall be relieved from any further obligations under this contract. However, the seller may also sue for damages. Okay. And down here you see where the buyer can sue for specific performance. Right. Now, assuming you're just going to go after the escrow deposit, here's what's important. The way it's going to be resolved determines on who's holding the escrow deposit. If a broker, title agent, title agent, closing agent, attorney, whatever, non-broker, non-real estate brokerage is holding an escrow deposit, if you guys can't resolve it, they're going to place those monies with the court, and we file what is called an interpleader action. Interpleader means, hey, judge, this is $50,000 that I have a buyer and a seller. They're arguing about who's entitled to it. Here are their names. Here's their money. Can you talk to them? Here's the suit. It's going to interplead. Inter means bring them in. I am bringing you into this pleading, buyer and seller, for you guys to present your case to the court to determine who's entitled to these funds, right? That's how a title agent or non-broker, I wouldn't say just title agent, but a non-broker is going to resolve it, right? The broker is going to use FREC's rules. FREC, they're going to go to FREC. They're not going to put the monies with the court right away. The non-broker agent just is getting that money out of their escrow account, putting it with the courts for the court to hold those funds, and then the dispute be resolved. Now, I'm going to tell you guys that doesn't happen very often. Generally, the parties get it together because there's a step that must take place first, mediation, right? The broker, they're going to notify FREC. We notify the court. A title agent notifies the court that there's a dispute. A broker notifies FREC. And FREC is going to put their wheels in motion. Now, but in the contract, it calls for, and this is where people get all hot and bothered, we'll just take the escrow deposit. There's a process for that, right? The process is, first you got to go to mediation. Mediation involves you going before a neutral third party where buyer tells their side of the story, seller tells their part of the story, and the neutral third party says, here's my suggestion on how you resolve this. The mediator is not the decision maker. They're not the end all be all. They cannot force the parties to do one thing or the other. They can hear both sides and say, here's how I recommend that you resolve this. That is mediation. If the parties have signed an agreement for arbitration, then they're going to go before, and mediation doesn't resolve it, Then they're going to go before another neutral third party, but the decision that that person makes, they're called an arbitrator. That is it. This is not, this is your recommendation. This is your recommendation. Do you agree? No, it is, here's my decision. Now, the difference between arbitration and litigation with a judge and a jury is obviously expense and time, right? You can quickly get in front of an arbitrator. The cost is not at all in comparison to what you would have if you have to pick a jury, assuming the parties request a jury trial, right? So if you could just conceptualize that in your mind, the difference between the two in the event mediation does not resolve this. Now, mind you guys, and this is why I advise parties when they get into these escrow disputes, all of this costs money in addition to the monies that are already being held in escrow. So most escrow deposits about $5,000, $10,000. I tell parties, let's say it's $5,000. If it's a non-broker, the parties are going to have to, from that $5,000, the cost of filing that interpleader action and the legal fees are going to be deducted from that $5,000. Now we're talking about what, $2,500? What are we talking about, right? And so now you need to hire attorneys to get back $2,500. Is it worth it? Probably not, right? $50,000, that's a different story, right? Let's assume it's a little bit more money. Let's assume it's $10,000. Now, mind you, no, let's use our same example, because y'all need to stay there. Now, mind you, again, even after these monies have been placed with the court, you still have to go to mediation first. Mediators charge, right? About $350 to $500 per hour, and they're going to require about at least 3 hours. Now we're at $1,500. This number is going down now, right? We were just at 25. Now we're at 1,500 for that amount. Now we're talking about $1,000 net. If the parties don't feel comfortable with presenting their case, now they're hiring an attorney, and they cost about $350 to $500 an hour. And they're going to have a retainer. They're going to request at least probably 5 hours. You guys understand where I'm going with this? These escrow disputes, guys, they're not worth it. Most times they are not worth it. They're not worth it. And so what the parties should do as realtors is figure out how to meet in the middle. Sometimes the best answer, because I've had it before, of course. I see everything as a real estate attorney. Sellers tired of, like, you get right to closing. Oh, they don't want to give them an extension on their, give them a couple more days to get their clear to close. Okay. What's the alternative? They're asking you for 3 days to get the clear to close. Title's already clear. Everything's in. What's the alternative? No, we're just going to go back on the market and keep their escrow deposit. Okay, wait. We'll deal with the escrow deposit discussion second. Let's talk about going back on the market. You go back on the market, go under contract, got your inspection period, file comes back in, we go through title again, we go through the lending process again, 3 days versus another 30 days. 3 days versus another 30 days. 3 days versus another 30 days. Oh, and by the way, check, we've had a conversation about that. Let's talk about this escrow deposit. That's not going to be dispersed right away either. That needs to go to mediation. We need to schedule a mediator. You need to attend mediation. You guys need to agree. If you don't agree, you need to either litigate or arbitrate, right? So my point is, I hope that you guys as professionals, that you're able to, number one, avoid the disputes. Number two, if the disputes arise, now that you have an understanding of what's involved with even accessing someone's escrow deposit, you can explain that to the parties, right? And make sure that cooler minds prevail. Now, the last thing to note is, if the matter does proceed to litigation, the prevailing party is going to be entitled to attorney's fees, not fast fees, attorney's fees and costs. Now we're talking about more money, right? So that's I hate to use this example, but if you're representing the buyer and the buyer is just heels dug in, no, 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 no. I am not, I am not at fault. My lender should have told me that they needed my tax returns. It is not my fault. No, I am not giving them my escrow deposit. They go to mediation. No, I am not giving them my escrow deposit. Nope. My lender should have told me. They go to litigation. Guess what? Judge says contract is black and white. You had a deadline to either cancel, extend, do something. You're in default. Your 50 grand is going to the seller. And now you're also paying them attorney's fees. Right? This doesn't happen all the time, but we got to make sure that we know this, right? Know what's at stake. So, key takeaways. Number one, monitor your deadlines. Number two, document action taken to address a deadline, right? Which is the same thing. If inspection period, you have a cash buyer, and during the inspection period, you identify some work that needs to be done, you need an extension. You need to extend that inspection period because that is your buyer's deadline. We can't just communicate this over the phone or by text, right? Because if there's a dispute, it's not in writing that I agree, not in writing, a signed writing between the buyer and the seller that they agreed to extend this inspection period. So make sure that everything is in writing. And then lastly, seek resolution of disputes before legal action, right? Again, we talked about this, and this part comes up more commonly than not, where, again, parties are frustrated, sellers are saying, I'll just keep their escrow deposit. Make sure that the party, your seller knows, potentially, yes, but there's a process. It's going to be time and money to do that, right? And then for the buyer, listen, we have to be sure that we maintain these deadlines. We cannot, if I'm following up with your lender, your loan officer, it is because I'm trying to protect your escrow deposit, right? I'm trying to protect your escrow deposit, because the last thing to make sure that you guys understand that escrow deposit cannot be released unless, number one, there's an executed release and cancellation between both parties, or order the court arbitration FREC, right? It's not just here, Rico, send the escrow deposit. No. All right. All right. Questions. Oh, you mentioned that escrow must be wired. How do you do that, since we usually present an offer with a check? Good question, Vicious. So the offer is not necessarily presented with a check. You make the offer on paper, right? You don't provide any funds, any exact funds. Definitely don't provide a check. What you could do, right now we're in a buyer's market, but when we were in a seller's market, i.e. COVID was our last true seller's market, what buyers would do was place their funds in escrow with the office, and we'll provide them with the escrow letter. So that's a way of telling the seller our funds are already in escrow, right? That's a very good way of showing that you are ready, willing, able, and serious. So wires, yes, sir. I'm sorry. Escrow deposits are made by wire. When the offer is accepted, contract comes into title. Title will send out the wire instructions directly to the buyer, not to you, not to anyone else. It needs to go directly to the buyer. Buyer needs to call the office and confirm the wire instructions verbally over the phone. No buyer should ever confirm wire instructions. They should never just simply accept wire instructions via email or any other means without calling to verify, right? Make sure that's in your buyer's consultations. Make sure that is in your signature blocks. That is in our signature blocks, right? Make sure that they understand that. There is a law regulation that indicates how much the escrow must be dependent upon the price of it. Oh, that's a good question, Arturo. No, there is no law. That is a very good question. There's a lot of factors that go into that. Number one, we have what's common, 10%, 5%. Someone may say 20%, but guess what? We're in a buyer's market now. I've been a party to some negotiations recently that I said, how the times have changed, right? And so whereas the sellers could have been more demanding for a larger escrow deposit, it is what the parties negotiate and they agree to. That's a very good question. The escrow deposit amount is a negotiated term. There is no law concerning how much must be made as the escrow deposit? Good to see you, Cassandra. Any other questions? Feel free to either type them in the chat or raise your hand. All right. In the meantime, we want to shout out some of our power learners. These are the ones who have shown up consistently where we've had email notification issues, just all the tech was going crazy. They showed up. And so that's Vicious, Dave, Della, Cynthia. You guys have powered through and you have shown up consistently over the last few weeks. And so we want to make sure that we acknowledge you, let you know that we are proud of your dedication to learning. Learn more to earn more. Learn more to earn more. Arturo, what's going on? I'm sorry, you have your hand raised. Go ahead.
Sorry, could you come back briefly to the first deposit and the second deposit? I didn't understand that. I believe both, if something happened, both are in risk. That's right?
Absolutely. Absolutely.
Okay.
The total deposit. Very good question.
Okay.
Very good question. The total deposit is at risk.
It's in risk. Okay. Thank you.
Very good question. Very good question. Guys, listen, ask all of your questions. Whether it's you think it's a minor detail, major detail, it's better to know and be sure than to not know and make a mistake, right? So what if Arturo assumed, oh, it's just the first escrow deposit? I'm not gonna give you any bad jujus, but we'll say you're on the seller side and he's telling the seller, well, it's only gonna be the first escrow deposit that is at risk. It's actually both. Or God forbid he's on the buyer side and say, well, yeah, you defaulted, but at least it's only the first deposit that you made. No, it's both, right? It's a very good question. In the chat, access to this recording, prior week's recordings, as well as our handout is in school. The QR code is on the screen. The link to it is in the chat. Jump in there. It is an app. It's another app. We're in the technology phase. It is an app called School. Go ahead and register there. In there, you'll see, if you move to the classroom, you will see access to the recordings and the handouts. We're gearing up. You introduce yourself. Ask your questions. We're gearing up. We're warming up the room, and just make sure that you have, make sure you access that. Lastly, we have dedicated purchase-ready webinars to this webinar room. Again, over the last few weeks, for whatever reason, emails go out, they bounce. Some of you, Della, for some reason, your email is just, your CB email it fights back. So you might want to
really
spam, maybe like a Gmail or something on there. We're going to reach out to some guys that are having that weird, literally seeing it bounce back is doing a hard bounce. But with that being said, purchase ready webinars is what we're going to use as the dedicated link to come into this room, right? We have made this webinar registration a series so that you're not having to get a different link each time. So you can save that link, or just know that purchasereadywebinars.com every Thursday at 12 p.m. Eastern will take you to where you need your portal to come into this weekly seminar, right? Weekly series. Lastly, again, not receiving our emails or updates, shoot me an email directly, raycolejackson@purchaseready.com. You're like, Raycole, I have not gotten an email in a week, 2 weeks. I know something is being sent out. Shoot us an email directly. We'll go into the CRM and see what's going on with your email and see whether something needs to be reset. Okay. All right. We got another question. Dave says, since all contingencies are built in the contract, are we supposed to add any content to additional terms to protect their buyers, sellers, or close? Absolutely. Absolutely. Dave is saying, should we add any additional contingencies? Sellers shall be responsible for closing out. I'm going to say this verbally. I have it committed to memory. Many of you probably already have this information built into the additional terms section of your contract templates, where it says sellers shall be responsible for closing out all unresolved open permits, unresolved code violations, prior to closing at seller's expense. Seller shall be responsible for closing out all open permits, unresolved permits, unrecorded code violations prior to closing at seller's expense. The reason why we add that language is because based on the way the as-is contract is drafted, seller is not responsible for addressing permits. It's actually in the probably in class 3 and in the handout as well. But let me just type it really quickly. Seller will.
So awesome.
Closing all unresolved permits, unresolved code violation prior to closing. And at seller's expense. This language you absolutely want in every contract. You represent a buyer, every contract. Because the last point I'm going to make on this, permits, unrecorded code violations, they are not title issues. They do not come up on our title commitments. They do come up on the lien search. But when the title agent, when my title team clears title, they have to clear according to the title commitment, not the lien search. Right? Saved it as a clause for simplicity, exactly. All right. And again, we're gonna do we hit the no, well, we don't hit this phrase in the last week, but we go over the title commitment. And so you guys, I'll reiterate on the in 2 weeks what our title team is responsible for clearing when a file comes in for closing. All right. All right. Lastly, outside of school, make sure you follow us on Instagram and Facebook. All right. For your daily dose of hellos and quick pointers. All right.
All right, guys. Quickly.
Go ahead.
So can I share this information and the Porsche Ready Academy and your information? I belong to a chat that there is around, I don't remember, 150, 170 realtors that we share information, some tips. Can I share that one in that chat?
Absolutely. You should send them to Purchase Ready Academy. Type that in the chat, please, Minnie. Purchase Ready Academy. So if they go to Purchase Ready Academy, it'll take them to. They'll see the schedule of classes for the week. For the month. They'll be able to register, and then that'll get them receiving the notifications.
I already registered by myself. Thank you.
So, okay. So save that send them that, give them the domain as well, purchasereadyacademy.com, purchasereadyacademy.com. All right. All right, guys. We did it. It is 1 o'clock. Go get it.
Thank you.
See y'all next Thursday.
Yeah. Thanks again, Nicole.
Not a problem. Good to see everyone. Bye-bye.
Awesome class.